Good evening, friends. When we started the journey of knowledge sharing, and one name which we started in the initial stages was Mr. P.S. Rajagopal, a senior advocate. And I think, though this session is 10th on the service law, but we have done a team number of sessions with him. We just deliberately took a pause on the service law series, and back we are again. Disciplinary proceedings and judicial reviews, one of the aspects where day in and day out, there are gray areas. I will say that in every aspect of law, there are always gray areas. And then they say that is the reason that the law flourishes in both ways. We are thankful to Sir for accepting our invite, and we are also thankful to Mr. Trivikram and Justice Chandrasekhar for introducing such a person who is an epitome of knowledge as well as thorough gentleman who also helps us to navigate how to proceed further in the judicial journey and how to read about the judgments, etc. That question and answer series will be at the end of the session. And over to you, sir, and thank you for accepting our invite.
Thank you, because I should first state this subject of disciplinary proceedings and judicial review. It is at the viewer's choice. Vikas sent me a message that he had received from one of our followers who regularly follows this series. Why don't you get Mr. Rajagopal from Bangalore to speak on the circumstances under which penalty can be interfered by administrative tribunal and high court? The same message he forwarded to me and said, is it feasible? I said, it was just less than 48 hours ago. And I said, yes, it would be interesting. Now, one difficulty in this judicial review of disciplinary proceedings or disciplinary action or whatever you call it, the key phrase we often come across on the question of judicial review of disciplinary proceedings or ultimate action taken is the phrase reasonable opportunity. You go to defense, we always say that employee should have a reasonable opportunity to defend. When you come to quantum of penalty, penalty should be reasonable and not excessive. When we come to the even definition of misconduct, the normal phrase we come across is every wrong cannot be a misconduct, and the word misconduct has to be interpreted reasonably. And the word reasonable and reasonable opportunity, they can be challenging in certain situations. This I'll tell one example. Take the case of a discretionary exercise of power. In our day-to-day functioning, most of the mid-level and senior level officers, say in the government, deputy secretary, I would say joint secretary level and above, they will have to make a choice in almost every case. Choice between available alternatives. Making a choice out of the alternates available is exercise of discretion. And everybody will be clapping as long as the consequence of that decision is not something which becomes a subject matter of debate or a subject matter of controversy or subject matter of likely loss to the employer. In all such cases, mechanically disciplinary proceedings cannot be initiated, and the entire situation will have to be viewed reasonably The underlying idea is that every wrong decision, as long as it is bona fide, every wrong exercise of discretion, as long as it is not vitiated by extraneous considerations, cannot be treated as misconduct. Therefore, whatever I speak today, please remember one thing. Some of the statements may not be of universal application, but it would depend on facts and circumstances of the case. But at the same time, there are certain concepts which are constant and would be applicable to all situations. First, when can disciplinary proceedings be initiated? In the days of absolute absence of industrial democracy, or says a few centuries ago, what is misconduct would be decided by the employer. There is no a priori previously defined or previously enumerated misconducts. But suddenly the employee would receive a notice saying that your such and such an act has been treated as a misconduct, because one important aspect of this disciplinary proceedings is that disciplinary proceedings can be initiated only on acts of misconduct. If something is not a misconduct, no disciplinary proceedings can be initiated and no penalty can be imposed. For the first time, in the Government of India Act 1915, an effort was made to codify what is a misconduct on the part of a government servant. It did not say it in so many words. It did not enumerate in elaborately as to what is a misconduct. It stated that the government servant should be told as to what is the misconduct alleged against him before taking major penalty action like reduction in time, reduction in rank, or dismissal, or removal, or compulsory retirement. From then onwards, the law evolved as to concept of what is misconduct and what is not a misconduct. Then came the Government of India Act 1935, which virtually, insofar as the protection of government servants who hold a status, because insofar as service in public sector is concerned, the courts have always held that the employee has a status and the employment is not contractual, because there is nothing called as master and servant. At the same time, every government servant holds an office of status. After the Government of India Act came, even before independence, on the industrial law front, Industrial Employment Standing Orders Act 1946 was enacted, which stated that acts of misconduct will have to be codified. How it stated was, in respect to the schedule items, the Standing Orders Act should contain definite and clear provisions. That is the first time when law came to be enacted, which required that employer should define what are the acts of misconduct. Even thereafter, what was happening was until I would say until 1985. It was in the year 1985 that Glaxo Laboratories case came. But before I proceed with the Glaxo Laboratories, let me tell one thing. It is an inherent power of the employer to take disciplinary action. One thing is power to appoint includes power to dismiss, power to remove, but the power is not absolute. It is subject to reasonable restrictions because in a democratic country like ours, no power is democratic, no power is absolute. And even when it comes to question of pleasure term, in our nation, there has been no absolute pleasure term as it existed in English law. In English law, Crown would be pleased to dismiss or dispense with. Such absolute pleasure is not available in our law. Therefore, one thing is power to take disciplinary action is inherent. Earlier, one of my lectures, I have spoken about the circumstances under which an inquiry can be dispensed with. And I would not like to venture into that area. Suffice for our today's discussion that as long as employer-employee relationship subsists, power to take disciplinary action is inherent in the employer. The effort of the law is only to codify and keep that power within the two definite bands so that the flood would not go unguided and cause unexpected havoc. The concept of judicial review or concept of rules governing the disciplinary proceedings is only to keep the power of the employer contained within defined boundaries so that the employee knows what he should not do. He may not know what he should do. That is what he should do is a different aspect. Doing a prohibited thing is misconduct. Therefore, as long as the relationship subsists, the power is inherent. But once an employee retires or superannuates, the relationship terminates. Thereafter, to take any action, it is to be specifically provided by a rule. First judgment in this regard is, I think, M.H. Majumdar from Bombay, where it said that post-retirement proceedings is not stricto sensu post-retirement proceedings is not stricto sensu disciplinary proceedings. It is only a proceedings to regulate the post-retirement benefits. This arises because in most of the service rules, particularly where the service is pensionable, usual clause is there in every pension rule that pension is subject to future good conduct, and any loss caused to the employer due to an act of gross negligence on the part of the employee while in service may result in recovery from pension, forfeiture of pension, either fully or partly, either permanently or for a defined period. In Bhagirathi Jena, Supreme Court said that was the case of an employee of the Orissa State Financial Corporation. Supreme Court said even curtailment of retirement benefits has to be provided by a rule, and unless there is a rule or regulation which authorizes the employer to continue the proceedings or initiating proceedings after retirement, is invalid. Therefore, post-retirement, the disciplinary power is restricted by existence or non-existence of a rule. Whereas, while the employee is still in service, it is an inherent power. Now, what is a misconduct? I was coming back to the Industrial Employment Standing Orders Act. It was in Glaxo Laboratories that the question came up whether an act which is not defined as, which is not enumerated as a misconduct, can still be considered as a misconduct ex post facto. That is, take this situation where the employer has defined the misconducts as required under the standing orders, and those standing orders are certified under the provisions of the Industrial Employment Standing Orders. Supreme Court held that if the act cannot be brought within any of the enumerated misconducts, there is no power in the employer to proceed against the employee in a penal proceedings, that is like disciplinary proceedings. Therefore, the first ground on which judicial review of disciplinary action can happen is where action is taken in respect of an act that is not a defined misconduct under the service rules or standing orders applicable. Otherwise, if the situation is something otherwise, the employer will have absolute discretion to say, pick up an act which is not a defined misconduct and expose him to the risk or of the disciplinary action ex post facto. It will have to be defined. But as again, it has to be reasonably interpreted. After the judgment of Supreme Court came in Glaxo Laboratories case, enormous writ petitions were filed before various high courts, contending that this is not a defined misconduct. Say, for example, take the case of a conductor in Road Transport Corporation. At that point of time, most of the discipline and appeal regulations did not say in so many words that collecting fare and not issuing ticket is a misconduct. It was not stated so in the regulations. Trying to take advantage of that omission, number of writ petitions were filed all over the country, saying that no action can be taken against a conductor for not having issued the ticket, even after collecting the fare. Look at it, the illogic. It is a straight case of misappropriation. Then it may be true that it has not been defined as a misconduct. Then invariably, high courts all over the country held that it is the standing orders will have to be reasonably construed. When he says that, when the standing order says disobedience of any rule or regulation having the force of law is a misconduct, it includes collection of fare and not issuing ticket would also come as a misconduct within that phrase. Then came the Rajagopal Patel. In Rajagopal's case, it is a very, I tell you how the history repeats. Just about a week ago, I was going through a judgment of the Supreme Court, which said that a judicial officer, before retirement, before recruitment, before appointment, he had suffered removal from government service. That fact had not been stated in the application for employment as a judicial officer. The judicial officer was proceeded against for suppression of material facts and securing employment. Then the Supreme Court held that it is not such a serious issue because long anterior to employment as in judiciary, he had ceased to be a government servant. Therefore, this could not have invited the punishment of removal from service. The situation in Rajagopal was identical. What had happened was that the employee had suffered removal earlier in the government service, Thereafter, he has joined without disclosing that fact another service. Then the standing orders, the disciplinary proceedings were initiated. on the ground that employee is guilty of suppressive, very and suggestive falsity, he having not disclosed the fact that he had been removed from earlier service. Application for employment contained that details of the previous employment should be given. But it did not insist that reason for exit from the previous employment should be given. Interpreting the standing orders, the Supreme Court held that you cannot treat it as a misconduct because there was no requirement under the regulations that disclosure, non-disclosure of a reason for leaving the earlier service or exit from the earlier employer requires to be stated. It was thereafter that most of the service rules were amended, stating that use of any unfair means in the recruitment examination or non-disclosure of material facts while seeking employment would be resulting in termination or disqualification, and that is how the law evolved. Last of this triumvirate, I would say these three judgments are very important to understand what is a misconduct and what is not a misconduct, and when the employer would get jurisdiction to proceed against an employee. The last of the series is A.L. Kalra. There the charge was that the employee had availed a house building advance, which the rule of the house building advance required that when advance is drawn, the site will have to be purchased within a definite time frame. Rule also provided, in case of failure to meet that time frame, time can be extended under certain circumstances. Or if time is not extended, the advance can be recalled and the employee is bound to repay with interest. This was treated as a misconduct because one employee had not been able to buy the site after availing the house building advance, which was treated as a misconduct and he was removed from service. Then Supreme Court said, the house building advance rules is a complete code by itself. The rule provides only for two consequences. One is recall of the loan prematurely. Second is employer's liability to repay it with interest. There is no third consequence envisaged under the house building laws. Therefore, as long as there is no regulation, the regulation does not itself say that there is a third consequence of disciplinary proceedings. Disciplinary proceedings taken for non-utilization or misutilization of the house building advance cannot be treated as a misconduct. This is therefore the first principle where the court can interfere with the disciplinary action taken is where the entire allegations set out in the charge memo do not constitute a misconduct as defined under the applicable rules. Then the initiation of disciplinary proceedings. Here again the law is if the employer, in a very employer's rules, there would be a codified definition as to who is the competent authority to initiate disciplinary proceedings. Of course, in the government rules, what it says is disciplinary proceedings can be initiated either by the appointing authority or by the authority to whom it is subordinate. In some other rules, it is specific. Say, coming back to the case of State Financial Corporation or Industrial Finance Corporation, it says the appointing authority or defined authority, say general manager, can initiate disciplinary proceedings. And in some other rules, it says that an authority competent to impose any penalty, because I emphasize the word any penalty, can initiate the disciplinary proceedings. If the disciplinary proceedings are initiated by an authority who is not competent to initiate, then the entire proceedings will be void ab initio. And such a proceedings can be interfered with even before commencement of the inquiry proper, at the charge memo stage itself, or even if the inquiry is continued and after the penalty is imposed, if it is challenged, it will have to fail only on the ground of lack of competence. As I was telling, the question is, suppose take a case where there is more than one authority in a graded structure where minor penalty can be imposed by some officer, and major penalty will have to be imposed by some higher officer. Interpreting such a rule, the courts have held that when it says that disciplinary proceedings can be initiated by a officer authorized to impose any penalty, even an officer who is entitled to impose only a minor penalty can initiate regular departmental proceedings, and on conclusion of the proceedings or not receiving the inquiry officer's report, if the employer feels that the facts and circumstances of the case are such that it warrants imposition of a major penalty, he can then remit the matter to the higher authority who is empowered to impose a major penalty. Therefore, incompetence to initiate by rank is another circumstance in which the state courts can interfere about with the penalty. Then the third stage is once the charge sheet is issued. This is a very normal ground that is raised by almost every employee who is subjected to discipline. There is the concept of reasonable opportunity. What is the meaning of the phrase reasonable opportunity? As I was telling, it is a very, very difficult concept to define. What is reasonable opportunity in one circumstance may be less than reasonable in certain other circumstances. Therefore, the law regarding reasonable opportunity and law regarding natural justice will have to be applied on a case-to-case basis, depending on facts and circumstances of each case. Now, reasonable opportunity consists of several facets. First facet of reasonable opportunity is that the employee must be told in clear terms what is the misconduct alleged against him. That is to say, the charge should be specific and definite. It cannot be an unclear or vague charge sheet. Take the case of Mohammed Sharif, where he was a forest officer in charge of several hundred acres of forest. A charge was leveled against him, saying that you went hunting in the forest, etc., etc. When he went is not specified. In which part of the forest this occurred is not specified. It was not understandable or discernible as to the case which the employee is supposed to defend himself. Then the Supreme Court said, this charge is so vague. You have not specified when, you have not specified where, you have not specified what. Therefore, the charge is vague, and on that ground itself, the penalty of removal or dismissal imposed on him will have to go. That is Mohammed Sharif versus State of UP. There may be State of UP. It is a State of UP versus Mohammed Sharif. The definiteness is what is required to be insisted upon. The first, the charge should be specific. Subsequently, this was slightly earlier to Supreme Court said, articles of charge should point out what is the rule that the employee is supposed to have breached. Take the case where allegation is you have violated a government order. If only such vague statement is made, it cannot be a specific charge. When allegation is that the employee has violated a rule, the charge must state which is the rule that is violated and whether that rule is a published rule. Because in a society governed by rule of law, law must be made. That is first part. Second part is, and it must be made known. Unless a law made is made known, it cannot be effective because, as said in B.K. Srinivasa, a law-abiding citizen must know the law so that he can be abide by it. Therefore, it is not enough if law is made, and more importantly, the law should be made known. Thirdly, it should state what is the basis for you to say that I have violated that government order. That is, fact constituting the stipulated rule of conduct must be included in the charge sheet. Then it should also contain the basis for that allegation. What would be the basis for the allegation? Basis would be some documents or some oral evidence. Therefore, it should contain all this. Now, of course, a standardized format has come where first part will be articles of charge, second part will be statement of imputations of misconduct, third will be the list of documents by which, fourth will be list of document witnesses by whom the charges are proposed to be. If all these four parts read together, if they do not make the case specific to be, which is capable of being understood by an employee and enter defense, then the charge should fail as a vague charge. This has been illustrated in first in Savai Singh, it was said. Thereafter, in Raipur Bilaspur Gramin Bank case, it has been elaborately dealt with by Lordship Justice R.V. Ravindra. And that is a good guide for us to say under what circumstances a charge can be challenged as vague. Then comes the vagueness part of the law itself. Some judgments have taken a view that if an employee has replied the charge memo without raising objection as to vagueness, it will not be open to him to say at a later point of time that the charge is vague. But at the same time, in Savai Singh, Supreme Court has taken a different view altogether, where Supreme Court has said that even if the employee does not raise the ground of vagueness of charge in his defense, it does not absolve the department from proving it by adducing necessary evidence. Therefore, the law itself is vague as to when the defense of vagueness has to be raised. Therefore, the safest course is to say that I have raised this defense at the earliest available point of time. Therefore, we have professional advocates for whom advocacy is a profession. There are professional defense assistants also in every service, be it public sector or the government. Normally, they say, the first sentence they say is, charge is incompetent. Second sentence they say is, this does not constitute a misconduct under the applicable rules. Third is, it is so vague I am not able to understand. If the defense statement stops at that point, no difficulty. But after saying so, I have not been able to understand the charge. The employee submits 100-page defense, which shows that he has fully understood the charge. Then this ground of vagueness may not carry you any further, except in rare cases. Because he might have given 100 pages reply, assuming the charge to be something, but actually what is operating in the mind of the employer may be altogether a different thing. Therefore, the law on the vagueness is this. If it is not, it should be capable of being understood by a man of ordinary intelligence, and it should be capable of being answered. That would be the standard of precision in drafting of the charge. Who can be thereafter, once the defense statement is submitted, after crossing the hurdle of vagueness, then comes the inquiry. In the inquiry, first question that would arise is, who can be the inquiry officer? Law is settled on this aspect because of certain things. The inquiry officer should be a person who has not involved himself in any part of the preliminary proceedings. Normally what happens? Before deciding to initiate a disciplinary action, there would have been a preliminary inquiry. A person who has been associated with the preliminary investigation, he should not normally be appointed as an inquiry officer. I can even remove that preface, the qualification normally. I can now say with definiteness that a person who has expressed a particular view before the commencement of inquiry should not be made an inquiry officer. Second requirement is, the first requirement is factual bias. Second requirement is an implied bias. Implied bias is the inquiry officer should be a person of higher rank than the charged employee. Why this restriction is there is, suppose there are two persons holding the same rank. One is appointed as inquiry officer, another is the charge officer. And their situation is such that unless the charged officer is held guilty and kept out of zone of consideration for promotion, the inquiry officer's promotion would be affected. In the sense, the charged officer being a better performer, he may get promoted. That is what is called as, present day we use it for every decision-making process. The phrase is conflict of interest. Conflict of interest in relation to disciplinary proceedings is that the career interests of the inquiry officer should not be in conflict with that of the charged employee, so that the inquiry officer will be in a position to apply his mind in a balanced, unbiased manner. But like the allegation of vagueness, even the question of bias sometimes, or most of the times, can be held to have been waived if the employee does not raise this defense or raise his objection against the appointment of a particular officer as inquiry officer at the proper time. You cannot just participate in the inquiry before an inquiry officer. And you cannot raise the ground of bias after he submits a report holding you guilty. Therefore, except where you have waived the objection of bias by acquiescence, courts can interfere where the inquiry officer is held to have been biased. Next question is, it is gloriously answered in one case in respect of a judge. What is the test of bias? Can you examine the findings of the inquiry officer on the basis of evidence and then come to the conclusion that inquiry officer was biased? No. The answer is likelihood of bias would vitiate the inquiry. Likelihood is different from suspicion that he may be biased. Likelihood means the fact circumstances must be such that a person of ordinary prudence would raise a presumption that, yes, this man is likely to be biased for reasons 1, 2, 3, 4. Therefore, the test is of likelihood of bias. When it came to judicial determination, I think I must have told this in one of my earlier talks. Rajagopal Majumdar, speaking for the Supreme Court, he said, the point is not whether bias has actually played a part in rendering the decision. An unbiased judge on the facts of the case might have arrived at the same judgment even otherwise. But that does not validate a judgment rendered by a judge against whom it can be said that there is reasonable likelihood of bias. Therefore, bias vitiates irrespective of the ultimate outcome. But only question is, bias will have to be raised at an appropriate stage, at appropriate time, and definitely not after taking a chance by appearing before him in the expectation of a favorable order and crying hoarse when order is against you. Bias is one aspect. Any opportunity given to defend even beyond limits of the requirement of rule, if the officer is biased, if the inquiry officer is biased, it cannot be saved. On this, Manaklal speaks of waiver of bias. Then yes, Parthasarathi. It speaks the effect of bias. Then how bias will operate is spoken in three judgments. Muhammad Nu, then management of one private school, that is Lordship Justice Venkatachalaya has rendered the judgment. And then Justice Sagir Ahmed's view in Commissioner of Police case. These three judgments, if you go through, we will be reasonably assured of understanding what is likelihood of bias and at what stage this ground of bias will have to be raised. Then comes another facet of reasonable opportunity, that is in the inquiry. In the inquiry, what is the reasonable opportunity? If I have to put the reasonable opportunity concept in 3 sentences, one is all the evidence in support of the charges will have to be taken in the presence of the charged employee. That is the first requirement. Second requirement is the employee should have an opportunity to test the veracity of the evidence produced by the disciplinary authority by cross-examining the witnesses produced on behalf of the disciplinary authority. Third is, the employee should have opportunity to produce the defense he seeks to rely on in support of his defense. Therefore, 3 aspects of reasonable opportunity insofar as evidence is concerned. Evidence should be taken in the presence of the employee. Second, employee should have an opportunity to test its veracity. Third, he should be given an opportunity to produce defense in its evidence. Now, whenever we speak of recording of evidence, normal argument on behalf of the employer is that technical rules, the Indian Evidence Act, of course, now we have introduced another name, that is Bharatiya Sakshya Adhiniyam. They are not applicable to disciplinary proceedings. That also has been answered by the Supreme Court. And most quoted judgment on this aspect is Central Bank of India versus Prakash Chand Jain of 1969. There is a said, though many times it has been said that technical rules of evidence contained in Indian Evidence Act is not applicable to disciplinary proceedings or domestic tribunals. Nowhere it has been said that even principles of natural justice, which require the evidence to be recorded in the inquiry, in the presence of the employee, is also not applicable. Therefore, part of the natural justice is that these are the three aspects: the recording of evidence in the presence and all the cross-examination and producing. Then reasonable opportunity will be held to have been denied when the employee's right to cross-examine has been curtailed. How it can be curtailed? There would be preliminary inquiry. Sometimes it may not be also. During the preliminary investigation, the investigating officer would have recorded the statements of such various persons. If such person's evidence has to be relied upon, he should be produced in the inquiry and his evidence should be recorded in the inquiry. That is fine. Second aspect is the employee should have a reasonable opportunity to cross-examine. What is the reasonable opportunity? That is why most of the rules stipulate that statements of the witnesses recorded in the preliminary investigation will have to be made available to the employee at least 3 days before the commencement of recording of evidence of that particular witness. This 3 days time is required in the minimum to enable the charged employee to understand, assimilate, and decide on what aspects and on what basis I can cross-examine that witness. This is very important, right? Of course, even in the matter of disciplinary proceedings regarding the prior statements, in S.K. Sharma versus State of Patiala, Supreme Court has held that the mandatory provision of the rules governing disciplinary proceedings will have to be substantially complied with. And directory provisions, it depends on facts and circumstances of the case. Therefore, and then came the Kashinath Dikshit, even earlier to this S.K. Sharma. In Kashinath Dikshit, the employee was permitted to inspect the file regarding preliminary investigation. But copies of the statements recorded in the preliminary investigation were not made available. On the other hand, a synopsis was made available. Then the Supreme Court has said that it has curtailed the defense of the employee in as much as he required the prior statements to be with him throughout to effectively cross-examine the witness. That has been denied, and synopsis would not serve the purpose. Therefore, where it appears by denial of a document, right of defense has been curtailed or impinged, that will be a case where the ultimate penalty will have to go. Then, after the inquiry, what is the role of the inquiry officer? I am only covering those aspects which would give rise to making out a case for judicial interference with the ultimate penalty. There may be so many final aspects which I don't think I'll be able to cover. I have already almost reached my limit of 1 hour, and because should not be blamed on a Sunday evening. The next is the inquiry officer's duty. What is the inquiry officer's duty? He has to first understand what is the charge, because he has no power to give any finding on an aspect which is not contained in the charge sheet. Then he has to see what is the defense. The third thing is the evidence will have to be analyzed. Fourth is, on the basis of analysis of evidence, he has to arrive at a finding as to what allegations are proved and to what extent charge is proved, and then he has to give his finding whether the charge is proved, and if so, to what extent, that is, whether it is fully proved or partly proved. There ends the duty of the inquiry officer. But he has a duty to consider. Consider means what? I have come across even the reports of the Lokayukta. Lokayukta issues an observation note calling upon the employee to submit his say, and public servant replies. And remember, these Lokayuktas are all retired judges of the high courts. How they unfortunately treat the employees. I have considered your observation note. There is nothing substantial to deny, to overturn the allegations made against you. Therefore, I recommend disciplinary action against you. That is not consideration. Consideration means examine the pros and cons. Examine which of the two versions is acceptable to you. State why it is so. State why you are rejecting the defense version, and then arrive at a conclusion. This is what is considered. The meaning of the word consideration. Consideration has been interpreted. The phrase consideration has been interpreted by the Supreme Court first in A.J. Rana. That is, it is a simple case where the Company Law Board, when it can order summoning of a document, the last rule stated that after consideration he has to. He can. Then for the first time, Supreme Court said elaborately what is the meaning of the word for consider or consideration. Then recently in LIC of India versus A. Musilaman, Supreme Court has said about the word and the meaning and content of the word consider. It has to be considered. He may consider does not mean he is bound to accept the defense version. It only means that when a defense version is rejected, reason should be contained there. Therefore, an unreasoned finding of the inquiry officer, which in law is called as ipse dixit, is to be rejected. Now, after the inquiry report comes, prior to 42nd Amendment to the Constitution, a notice and hearing was required on proposed penalty. 42nd Amendment did away with it. Later, Constitution Bench Supreme Court in Karunakar's case said that what has been done away by 42nd Amendment is only hearing on proposed punishment. But hearing on validity of the finding of the inquiry officer is still available. Therefore, once the disciplinary authority receives the inquiry report, he has to call for the objections from the employee as to why the inquiry officer's report should not be accepted. After considering that, the say of the employee in answer to the second show cause notice, the disciplinary authority has to arrive at a conclusion whether charges are proved or not proved. And if the charges are not proved, obviously no penalty. If charges are proved, then the penalty. And by finding even about a week back or 10 days back, Supreme Court has held that when disciplinary authority agrees with findings of the inquiry officer, he need not give elaborate reasons. I beg to differ with that statement of law made by the Supreme Court, because suppose the case set up by the employee in answer to the second show cause notice is that the employer has not, the inquiry officer has not considered 1, 2, 3 these defenses. The inquiry officer has denied me reasonable opportunity by 1, 2, 3, 4. Are they not required to be answered by the disciplinary authority? They are required, because generally the service rules provide for an appeal against the order of the disciplinary authority. Thereafter, whether the rules provide or not, judicial review. It is not, the disciplinary authority is not a Supreme Court, which is not bound to give reasons. Not because Supreme Court cannot give reasons, but because there is no appeal against the order of the Supreme Court. In fact, in Karunakara's case, Lordship Justice Ramaswamy, in a separate but concurring judgment, said that the reasons, however brief, should be found in the order of the disciplinary authority, both as regards guilt as also regarding the quantum of penalty. That is an important safeguard. And notwithstanding little wavering sentences here and there, that is still a ground. Absence of reasons is still a ground that is available available for the judiciary to interfere with a particular penalty. Now, penalty. What should be the nature of penalty? Penalty should not be grossly disproportionate. Second, it should not be discriminatory. Suppose a joint inquiry is held. 2 or 3 or 4 employees are found guilty. The role of each of them is identical. Then you cannot discriminate in the matter of punishment unless the role of a particular one amongst the 4 or 5 joint delinquents is of a higher magnitude. Then about grossly disproportionate punishment. Supreme Court has repeatedly said that, quote, the choice of punishment is left to the employer. You cannot interfere except where it is so disproportionate that it shocks the judicial conscience of the court. This again becomes a subjective element in this sense. Some judges get disturbed very easily. Some do not. Therefore, an element of subjective determination comes there. But that is part of the law. We cannot escape it. Then about finding of fact. A court cannot interfere with the finding of fact recorded by the inquiry officer and accepted by the disciplinary authority or the appellate authority, except where it is based on no evidence. There must be some evidence to link the employee with the misconduct alleged. That is what is popularly called as. The evidence should be of the standard of preponderance of probabilities. I may be wrong. My understanding is that preponderance of probability means definitely it is much less than the reasonable proof beyond reasonable doubt that is required in a criminal case. But preponderance of probability means it should be sufficient to get a decree in a civil court. I have a reason to propound this. Though in no judgment, this has been said in the words I am putting it. If you take Narendra Mohan Arya, where the Supreme Court enumerated 6 postulates, para 26 of the report in Narendra Mohan Arya gives this 6 postulates, which every disciplinary inquiry should conform to. It also said, as a 7th postulate, elsewhere in the judgment, that civil judgment of the civil court inter partes, and that as a particular aspect, would bind the disciplinary authority also. Therefore, by inference, I am saying that the preponderance of probability means it should be the employee should be able to overcome that. He has to prove that. Even a civil decree could not have been obtained on the basis of the evidence that has come after. When I say some evidence, it must be admissible evidence and not what is not evidence. That is again traceable to Central Bank of India versus PC Jain. Then comes the quantum of penalty and all that. That's over. Then the appellate authority. Normally, the rules provide that appellate authority has to consider 3 aspects. One is whether the inquiry has been conducted in accordance with the rules governing the inquiry. That is the first part. First part of the first requirement. Second part of the first requirement is, if there is a violation, whether that has caused prejudice to the employee. Second is, whether finding of the inquiry officer, disciplinary authority, is justified. Third is, whether penalty is proportionate to the misconduct. These are the 3 aspects that the appellate authority is bound to consider. And if there is any shortcoming in the consideration, the matter will have to be limited to the appellate authority. These are broadly the areas which should be focused to get a relief against a wrongful penalty imposed in a pursuant to a disciplinary proceedings. But there are finer aspects in every facet that I stated that will have to be examined on a case-to-case basis. I can only say broadly to which corner of the proceedings you have to look to come out of the corner. The proceedings and penalty more often is fact dependent, a fact situation dependent. Therefore, deep application of mind is required to question a penalty. One more aspect I'll govern and I'll conclude. The question is whether findings of the inquiry officer are binding on the disciplinary authority. Obviously, answer is no. Disciplinary authority has got every right to disagree with the findings of the inquiry officer. But there are certain safeguards provided in law. And the question of prejudice will not apply to interfere in the absence of the following of these safeguards. Firstly, the disciplinary authority has to formulate a tentative opinion with reasons as to why the disciplinary favorable finding of the inquiry officer is not acceptable to him. Second is that reason formulated by the disciplinary authority must be tentative. Third is sufficiency of evidence. The rule says, normally would say that if there is sufficient evidence, inquiry, the disciplinary authority can disagree. That is the only circumstance in which court will be entitled to look into sufficiency of evidence when it is testing the disagreement recorded by the disciplinary authority. Otherwise, sufficiency of evidence does not fall within the domain of judicial review. I think I have broadly covered. I don't say because disciplinary proceedings is a matter where, unlike promotion, a book can be written on that, and there are a number of books. And you will be, most of the lectures or webinars on service law relate to disciplinary proceedings. Only broad contours of disciplinary proceedings and areas where circumstances under which judicial interference can be there. I'm grateful to all of you for having heard me with patience and spent Sunday evening. Normally, this is time when we see, at least when I am free, I see old Hindi movies or old Kannada movies, depending upon the channel I am looking at. Thank you very much. Thank you, Vikas.
Thank you, sir. Thank you. And the ease with which you were speaking on such a vast topic, it only shows that how much knowledge you have. The few questions were, like normally we ask, probably there was not much debate on this particular aspect. The role of principles of natural justice as such. Because sometimes we apply on the principles that there is also a concept known as doctrine of useless formality. So what is your take on that? Because we normally say that even when the Adam and Eve, the apple was eaten, they said that why did you eat the apple? And then the journey of natural justice evolved. So what is your take on this?
The useless formality theory that should not normally be applied in case of disciplinary proceedings, except where the charge has been admitted by the employee. And admission should also be unequivocal. Suppose there is equivocation in what could be inferred to be a admission, then also the inquiry will have to be held in accordance with the rules. Of course, where the delinquent has appeared before the inquiry officer and categorically admitted the charge, then of course useless formality theory will operate. That is why the service rules themselves will provide. If the employee admits, then an inquiry is stopped there, and the inquiry officer is entitled to record a finding of guilt and submit the report on the basis of admission. That is where even the principles of civil law, that the court may record a decree on the basis of admission. A discretion is there in the civil court, and when it is applied to this departmental proceedings, the inquiry can be stopped at the stage when the delinquent admits. While propounding useless formality theory, one was the Supreme Court has said two important safeguards. One is when it can be applied. Now, for example, I think this is where Lordship Justice S.B. Sinha said about, spoke of useless formality theory. Take a case where an employee has been appointed. When he does not possess the qualifications prescribed. Qualification prescribed is, let us say, it is a simple and straightforward qualification, like securing 55% of marks in postgraduate degree and passing a national eligibility test. And one of them is not possessed by the person appointed. Then the useless formality theory can be applied, because any amount of opportunity you provide to the appointee, he will not be able to establish that his appointment was valid. That is where the answer is obvious, answer is undisputable. The question of useless formality theory can be. But there is one condition. In another case which arose out of some exercise duty or some duty, Supreme Court said that administrators should not apply that useless formality theory. Useless formality can be applied by the court when the matter reaches the court and judicial review is sought, saying that this opportunity has been denied to me. Then it is for the court to say that it need not mechanically grant the relief merely because a rule has been violated or an opportunity has apparently been denied. It has to examine whether that opportunity, if granted, would have made any difference to the outcome. That is a test of prejudice that is applied in Karnataka. Therefore, generally, it should not be applied by the employer itself.
Next is, is there any distinction between the inquiry officer's role vis-a-vis the disciplinary authority?
The difference between the two roles is apparent. One is, inquiry officer is like a fact-finding quasi-judicial forum. Inquiry officer is not authorized to recommend what penalty should be imposed. But that is also subject to facts and circumstances of the case. In V.G. Teredesai, Supreme Court said, though the inquiry officer is not, it is not within the domain of the inquiry officer to recommend any particular penalty, the mere fact he has recommended so would not vitiate the inquiry. Only requirement is, while conveying the inquiry officer's report and seeking objections to the employee, his recommendation regarding penalty will also have to be communicated, and objections to the employee will have to be sought on that. That is the first difference. Second difference is that the inquiry officer is the basic fact-finding forum inquiry. The fairness in action, which is the foundation of any valid disciplinary proceedings, is tested more often than not by the fairness in the inquiry. Once the inquiry officer's report comes, the role of the disciplinary authority comes. What is the role of the disciplinary authority? I have already explained. He has no obligation even to accept the inquiry officer's report as sacrosanct. A finding of guilt recorded by the inquiry, or a finding of charge is proved by the inquiry officer is not binding on the disciplinary authority. He can still say that for these reasons I hold the charge is not proved. So also, a finding of not proved is also not binding on the disciplinary authority. He can say for these reasons I propose to disagree, and then after receiving reply to that proposition notice, he can disagree. Therefore, the disciplinary authority, the inquiry officer is, while he determines the question of fact after affording reasonable opportunity, it is in the disciplinary authority to test whether inquiry has been conducted in a fair and just manner, whether the findings are supported by evidence, and whether, looking at the conduct of the inquiry and the evidence collected, whether the report of the inquiry officer commends itself for acceptance, or is there a reason to disagree?
Yes. So, the next question is, what are the safeguards for a contractual employee? Because they say that you don't have any protection, or do they have any protection under the disciplinary proceedings as such?
Who? State employees?
No, sir, contractual employees.
Contractual employees.
I'm talking about PSU,
yes, yes,
state employees, not in a private organization.
Even if he is a contractual employee, if the order of termination is penal, in the sense, suppose it casts aspersions on the employee's conduct. Suppose the termination of a contract employment in accordance with the terms of the contract is not even retrenchment under industrial law. It can be terminated even during subsistence of contract in accordance with the terms of the contract. That is by giving 1 month notice, or sometimes 3 months notice, or notice pay in lieu of notice. Several provisions are there. Or by non-renewal on expiration of the contract period. In either case, it is not a it is not penal. Supreme Court has said, I don't remember the name of the employee, in which case it said, terms of contract, it was open to the employee to accept or reject the terms of the contract. He having accepted, if termination is made in accordance with the terms of the contract, the question of Article 14 or 16 would not arise. This is the phrase used by the Supreme Court. But look at Purushottam Lal Dhingra, where Supreme Court said, even a probationer, if his term has to be dispensed with, it has to be by after holding an inquiry, if it is for misconduct. Now, what is the foundation for termination? Either a probationer or a contract employee, whether misconduct was only a motive or whether the misconduct was a foundation. That is a matter which has to be decided on a case-to-case basis. In fact, the phrase motive and foundation confused Lordship Justice V.R. Krishna here. In one judgment, he said, I don't understand what is this motive and foundation. But even he could not get rid of that cliche, that is motive and foundation. Ultimately, if you read the order of termination and the accompanying and the defense the employer sets up before the court to justify the termination, if those two materials, if they indicate that it is punitive or it is stigmatic, then inquiry is compulsory even in respect of contract employee.
This is suspension considered to be a punishment, and under what circumstances the subsistence allowance, etc., is considered to be a role while considering the suspension? Because there's no one judgment which says that for 90 days, if you're not issued a charge sheet, Justice Vikram Sen's judgment to the effect that it can't be quashed.
Yes, long years anterior to judgment by Lordship Justice Vikramjit Sen, which incorporated right to speedy trial as a facet of Article 21 and applied it to suspension, and said that if the charge sheet is not filed within 3 months, the suspension should lapse. If I remember correct, in 1960, between 1962 to 65, or slightly earlier to that, there was a directive from the Union Home Ministry that when an employee is under suspension, pre-charge sheet period plus post-charge sheet period should not exceed 6 months. If it exceeds 6 months, reasons will have to be recorded as to why proceedings are unable to be completed within that period. About the reasonableness of suspension, if anyone of you can lay your hands on judgment of a learned single judge of the Karnataka High Court, that is Lordship Justice H.L. Dattu, who later became Chief Justice of India. I had argued before him for an inquiry which ultimately took only 2.5 days, including 1 day of preliminary inquiry. The employee had been kept under suspension for 10 years, almost. Then I raised this question of justifiability of the period of suspension. The learned judge broke up the period of suspension into 3 or 4 blocks and held that this block is justified, this block is unjustified, this block is justified. And ultimately, out of the 10 years suspension, about 9 years on that was found to be unreasonable. Therefore, particularly suspension is at a stage when the employee has not been found guilty. Suspension is not preceded by natural justice. Suspension causes more agony to the employee than the dismissal itself. Because once an employee is dismissed, he does not go to the office, or he need not meet his colleagues because there will be no colleague relationship. An suspended employee, he has this agony of stigmatic boycott or stigmatic whispering campaign going on within the range of his years at a stage when no allegation is proved. Therefore, Lordship Justice Vikramjit Sen is justified in imposing that concept of Article 21, which he adopted from Abdul Rahman Act, arising from criminal proceedings in the case of suspension. And there are cases and cases where suspensions are prolonged unjustifiably. And a justified suspension at one point of time may degenerate into unjustified prolongation in a given fact situation. That can be overcome because particularly that is why in the service rules it is stipulated. The discipline authority has to decide what period he will be entitled. Of course, in respect of dismissal or compulsory retirement, it says that the entire period will be treated as not on duty. But even in such a case, it must be possible for us to say that this period of suspension is unreasonable and unjust.
So one of the questions on the chat is, please share your findings on, not findings, please share your insights on reverse findings.
In respect of, please?
Reverse findings.
Yeah.
Like we say that the findings recorded are reverse. So what are your intakes on this? What is the
Perversity, you are asking. Perversity is a finding of the inquiry officer can be said to be finding, perverse finding, when it is based on no evidence, or when no reasonable person could have come to the conclusion which the inquiry officer has arrived at on the basis of evidence before him. One is total absence of evidence. Second is a perverse finding or a distorted view of the evidence to such an extent that it defies all logic and rationale. Normally, it is said that writ court would not interfere with the finding of guilt. But read the judgment of Justice Sagiram, where he explains what is perversity of finding. And he says that where the inquiry proceedings show that there is absolutely no evidence and absolutely the inquiry officer did not sit with an open mind and his brief appeared to be to fix the employee, then the constitutional court can interfere with the findings. And even a civil court where the suit is initiated, it can also, that is Kuldeep Singh versus Commissioner of Police, 1999, 2 SCC page 10, where he uses the phrase, the inquiry officer did not sit with an open mind. And it was as if his mandate was to fix him up. Where 3 allegation of bribe receiving bribe from 3 parties was the allegation. 2 were listed. 1 of them was not examined. One was given up before the commencement of the inquiry. Another was withheld during the inquiry. And without any reason, the inquiry officer had attributed absence of that witness who was withheld from the inquiry to the charged officer himself, saying that he got employment for that witness elsewhere without any basis or foundational evidence, where evidence is totally lacking and where there is no reason assigned why the defense evidence is not acceptable, then it will be treated as a perverse finding. Or perverse finding is mere, like in Vishnu Sahasranam, there is a Arjuna Uvacha or Bhagavan Uvacha or Bhishma Uvacha. That Uvachas will not work. Anything based as a Uvacha in inquiry officer's report is a perversity. Because he is not a religious pontiff to say that this is Papa, this is Punya.
Yes. So thank you, sir, for sharing your knowledge. It was actually a delightful session for so many brownie points to be taken up. We are glad to hear you and enrich our knowledge. And today's session was slightly more elaborate. Thank you, everyone, for joining us, and stay safe, stay blessed. And we are waiting for sir's new book to come. Over to you. Thank you, everyone.
Thank you.
On behalf of Vikram and Beyond Law CLC, we are thankful to everyone who has joined us.